We have an opportunity right now to really set right a problem which we've been plaguing us for the last 20 years, litigants being run between court to tribunal and vice versa. Or do we dig ourselves our heels inside and say, sorry, there's nothing that we can do. This is how the system is. We submit it's the former, that is an imaginary problem. Section 5 is not really a valid answer to the problem. Section 5 is actually a gateway, not an obstacle. Section 5 permits a Section 34 court to intervene in any manner it wishes to once the gateway is open. Because Section 5, the last part of Section 5 reads that the court may intervene where so provided. It doesn't say in the manner so provided. The reading of Section 5 is only a gateway to get inside. And once that opportunity is there, whatever powers the court wishes to apply are available to it. It appears at the end of Section 5, my lord. The second is, to what extent should there be corrections permitted to an arbitration award? And we submit, and this is a very important aspect, because if your lordship's hold is it should not be done too widely, because we'll have another problem being opened. We submit it should be restricted to certain aspects only. Number one is when there is a non-discretionary aspect, that is either there is a statutory right or a contractual right. One. Two is if it is a matter of modification of an interest. And three, if there's any calculation related errors. Now, it is why this is so important is because it leads to the entire concept of enforcement of rights, what a statute provides. If the tribunal is not either rightly or wrongly ordering that, awarding that, if a court does not correct that, it puts a big question mark on ease of enforcement of contracts, on the rule of law that we're enjoying. Because then the moment you see litigation dragging on, somebody going from court to tribunal, it casts a question on our ease of doing business in India, which is why there must be certainty, finality, and efficiency in the entire process. Therefore, these are from a policy perspective. I think the legal points have already been very adequately covered by my learned seniors. Now, we've tendered a note. In that note, my lord, we've already dealt with a series of judgments which already my learned colleagues have dealt with as to where the court has previously interfered with awards. The only relevant one I want to show, my lord, is the Hindustan Zinc versus French coal carbonization. In that, the Section 34 judge modified an award. A Section 37 judge, the 2006 4 SEC, the Section 37 judge set aside the Section 34 order on the basis that it should not have been modified with. The Supreme Court said
page number
2006 4 SEC 445.
2006
4 SEC 445. Hindustan Zinc versus French coal carbonization, where the Supreme Court upheld the Section 34 order allowing the modification. And that is the correct system we submit that must be followed.
But what was the modification made? What was the modification made?
Yeah. It was on the main merits of the matter it had gone on to, on the calculation of the damages.
Computation of damages. Where is the reasoning given? But without reason, they just applied.
Para 25, 24 onwards. The basis of the calculations.
It is on the basis of calculation.
Last line, the order of the division bench is unsustainable as it fails to interfere with a portion of the award which is opposed to the specific terms of the contract. On the other hand, the trial court had correctly decided the matter. So in that category of if it is a contractual right, statutory right, interference must be there. If it is calculation of an error,
Statutory right, then you are rewriting the award.
Only to this limited extent where there is no discretion.
No. When
Yes,
say in a contract says no escalation, come what may,
then there is no discretion.
even if we extend the time, arbitrators normally find a way to get over these clauses.
Correct.
Because in equity, these clauses are one-sided, completely one-sided. There's a platform contract.
So if the court feels that
If we do that, then virtually we will be rewriting the award.
So just to correct, rewriting the award to a limited extent is not a bad thing. Rewriting the award up, because if one follows a policy that no rewriting is the policy which is being advised by by the other side and is the one that is causing the problem. So partial rewriting in these limited circumstances should be permitted for a systemic benefit is what our submission is. So if there is a discretion to the tribunal, then court should not interfere. But if there's no discretion, if there's a contractual right, statutory right, then the court must interfere in those cases. We have to lay down limits.
Will setting aside include that part?
So that point has already been adequately addressed. So setting aside includes that limited right of modification and modification not quite, but with this limited aspect. My lord. Main point is the huge expense, effort that parties have undertaken to be nipped into the bud. Just 2-3 more points, my lord. There's another risk of this section 34(4) I'll just address. Is this if a court refers it back to the tribunal and tribunal maintains its view, this is the risk of an infinite bounce. It will come back in a 34. 34 may again hold its view. It's again a never-ending process, litigant suffering right throughout. Again on 34(4).
So we already argued so many times.
I just make 2 more points. 34(4), 90% of the entire work is already been completed. Why not just finish it instead of sending them back all the way to this? And at many times, the lordship should have seen tribunal is no more available either because of age or retirement. So a lot of practical difficulties are there in referring matters back to tribunal. So it is best from a commercial as well as practical and legal that the matter be closed at that stage. So we've seen international statutes. They provide for the power to modify. We've seen US, Singapore, Australia, England. The only one that prohibits is in Singapore in the context of international arbitration. In our case, we have a clean slate. So we have the opportunity to set right what we think is correct. And that is what we submit should be done. The statutes are already provided by Mr. Mehta in his written note. I'm grateful to my lords.
Please call out the name.
Please, Lords, while adopting the submissions of my erudite senior colleagues, Lords, on the reason why Lordship should in fact permit modification of awards, I want to focus on a very limited aspect. Lordship's repeated query during the course of this hearing has been, if we agree that this power is there, what is the Lakshman Rekha that we will draw for identifying the scenarios and the benchmark when this power should be exercised? So, my lord, I am only arguing on that issue because of the limited time available with me. Lordships may kindly have my written submissions, paragraph 4, where I have sought to encapsulate 3 scenarios where the Honorable Court may consider exercise of this limited power of modification. If Lordships would be so kind, my lord, to have my written submissions, if all the Honorable Judges have it, my lords, may I just place that?
Yes.
My lords, I am just requesting my lords to have with me paragraph 4 of my written submissions. I've also handed over extra copies, my lords, so any honorable member of the bench, I would deeply obliged. My lords, may I place para 4, just the initial portion. Various scenarios would arise where the interest of justice, as also institutional effectiveness of arbitration as a form of alternative dispute resolution, would be better subserved if courts can modify an award without relegating the parties to a second round of arbitration, provided that such a modification would not require a detailed inquiry into the facts of the case. Now, please see 3 scenarios, my lords. For instance, in one scenario, scenario 1, an arbitral tribunal may deny interest on the claims in toto. However, if the court determines in a section 34 or 37 proceeding that interest was unjustly denied, the court should have the power to modify the award and grant a reasonable rate of interest without relegating the parties to a fresh round of arbitration on this sole aspect. In another scenario, scenario 2, if the court determines that the interest granted by the tribunal is unsustainably high or low, the court should have the power to reduce or increase the interest rate without having to remand the parties to a fresh arbitration with regard to rate of interest. Now, these 2, my lords, are relatively low-hanging fruit. Now, please see the more controversial scenario 3. There might arise a third scenario, scenario 3, where the findings of the arbitral tribunal might be ex facie contrary to the record of the tribunal or the agreement between the parties, and modifying the award would not require an elaborate inquiry into the materials already placed before the arbitrator. Now, my lord, for this third scenario, I wish to place before my lord a judgment of the division bench of the Honorable Delhi High Court, which would show to my lord exactly why this limited curated power should be available. My lord, please have my judgment compilation. There are many judgments there. I'm only going to show lordships 2 of them because of the limited time that I have at my disposal. Please see this judgment, which is at serial number 1, page 1, IRB Infra. My lord, this is a new judgment compilation that's been handed over. I have removed my earlier one because most of it was already covered. This is, my lord, running into 79 pages. I hope Lordships has this judgment compilation.
Yes.
Yes, Lordships may just see the first judgment of the division bench in IRB Ahmedabad versus NHAI. My lord, the facts were interesting. The contractor in this case files a claim, which Lordships will find at paragraph 4 at page 2, seeking an award that it is entitled to issue passes without offering discounts to local commuters on the highway. So the majority award finds that yes, you are entitled. You don't need to give a discount to the local commuters. Now the NHAI filed a counterclaim, which I'll take Lordships to, which said no, direct them that they must provide the discount. Now in the section 34, the single judge sets aside the award. The contractor appeals to the division bench. The division bench upholds the single judge's order, but now please see what the honorable division bench does. So Lordships will now note this interesting formulation. Please have with me, my lords, paragraph 36 at page 15. This is a perfect example of scenario 3. Please see para 36 minutes at page 15. May I read, my lords?
Yes.
Before the arbitrator, the NHAI had filed counterclaims and prayed as under. In view of submissions made above, the claims of the claimant may be rejected and the claimant be directed to. Now, please note, my lords, Roman serial 1 and 2 are precisely the counter to the claim, which is direct them to issue discounted passes. Now, my lord, please see para 37. That's pregnant with legal consequence. The arbitrators in the award did not go into the counterclaims of NHAI, but granted the claims of appellant. Since the stand of the appellant has been rejected and award has been set aside, it is directed that the NHAI shall ensure that the concessional passes, discounts and exemptions as per notified toll rates are being extended to commuters and users. The appellant shall submit all its accounts within 8 weeks, who shall be entitled to recover all the excess amounts charged by the appellant. Now, my lord, the unarticulated premise of what the honorable division bench says is, it's a useless formality now to send the NHAI back to a fresh arbitration to again agitate its counterclaims, because the courts applied its mind and the courts found that the stand of the contractor is completely unsustainable. Now, in a situation like this, my lords, will the courts now relegate the parties back to a fresh arbitration for something that's ex facie clear? Now, my lord, one question which will come is, all right, this is one factual scenario. How do we lay down a test? Now, my lord, with my limited understanding, my respectful submission is, and I say it with all responsibility at my command, useless formality. Useless formality is a controversial doctrine in administrative law. Because Lordships knows in administrative law, there is this dichotomy between the principles of natural justice not being applied and admitted facts leading to a particular conclusion. So that's a controversial doctrine in administrative law and service law. But please see, my lord, if we remove that element of natural justice, which would not arise here, please see one formulation which I can commend for Lordship's kind acceptance. Please see page 56 of my judgment compilation, which is, my lords, part of the judgment of this honorable court in MC Mehta, which begins at page 49. Please have, my lords, page 56. Yes. Please have with me para 21. Now, this is in the context of useless formality in administrative/service law, but please see para 21. Now, Lordships may ignore the first words beginning with, it is therefore clear that. Please start with, if on the admitted. Please note this, my lords. Lordships has that. At yes. Para 21 at page 56, my lords.
Yes.
At 21, please ignore the initial words. It is therefore clear that. Now, my lord, please mark from here, if Lordships would be so kind. If on the admitted or indisputable factual position, only one conclusion is possible and permissible, full stop. In my respectful submission, for determining scenario 3, this strict test Lordships would consider employing, because in my respectful submission, and I will just end with that, arbitration is a chameleon. Lordship saw the judgment in IRB. Even though arbitrations are ultimately private contracts, in many ways, they overlap and interface with issues that affect the larger legal system. And my lord, these are not my words. Please therefore permit me to conclude with just one more reference. Lordships may have, my lords, in my judgment compilation, the article, my lords, at page 59. Now, this is, my lords, a 1952 article, which is considered the most unadulterated normative exposition of arbitration because of the genre and the era in which it arose, relatively uninfluenced by the commercial explosion that's happened thereafter. Now, my lord, this article, my lord, lordships may kindly see at page 59. And my lord, I will just take lordships to page 63. We think arbitration, we fetishize arbitration today as purely being this commercial agreement between two parties. But arbitration goes beyond that. Why does it do so? Please see page 63.
Yes.
Lordships may note the 5 components of arbitration. I will trouble my lords with A, B, and E. Please let me start with A. Arbitration as a creature of the parties. My lords has that, my lords, at 63. May I read?
Yes, please.
Yes. The statement that arbitration is a creature of the parties, that its occurrence, form, and scope are dependent on the will and consent of parties is but part of the truth. Although the arbitration agreement, as any agreement, is consensual within its limited compass, it is also in varying degree depending on the law of the particular jurisdiction. Now, please note, my lord, a delegation of the power of the state to private parties for their private ends. That delegation proceeds on the assumption that the attainment of those ends will also subserve public interest with a sufficiently high degree or incidence to justify such delegation. The basic assumption is, as we pointed out in the preceding section, that arbitration is an allowable extension of the sphere of contract, yet the fact that it is consensual profoundly affects the nature of the award and the value sought to be served by the award, and hence the determination at the ends of the attainment of which the power of the state will be brought to bear. Now please see B, arbitration as an award. The fact that the arbitration process involves a delegation of the power of the state also must be considered in the evaluation of the process, for the exertion of this power will channel conduct within or between institutions as the case may be, and thus have consequences with which society must be concerned. Now, my lord, please see arbitration as a settlement of a dispute. This is what we primarily focus on, to the exclusion of the other elements. Now, please see D, arbitration as a procedure before a tribunal. This also we focus on. Now, please see E, my lord. This is critical, which is why the court's exercise under 34 and 37 must be cognizant of this complexity. Please see E, my lord. Diverse nature of the arbitration process. It will be evident from the foregoing that one of the fundamental propositions of this article, that it is erroneous to assume that the arbitration process remains the same and is uniform wherever the elements of its structure appear. It is erroneous to assume that arbitration is purely a structural concept definable by the occurrence of the elements noted in the definition at the outset of this article. An individual may be identifiable by the presence of a typical sentient anatomical structure. The personality of an individual, however, emerges when he is viewed in a social context. Similarly, the nature of an arbitration becomes revealed when it is viewed in its social context. For arbitration is a chameleon word, assuming varying significance as the social setting in which it takes place. Now, my lord, after this normative exposition, jurisprudential in nature, please see its application to commercial arbitration. That is what today we mostly engage with. Please have with me page 77. I'll conclude with this. Please bear this in mind, my lords. Please see page 77. Please see Roman 10, nature and role of commercial arbitration. I'll just read this one para and conclude. Yes, may I read? The term commercial arbitration implies the arbitration of disputes arising in the life of trade and commerce. A dispute involves a deviational transaction in which an established customary expected course of conduct fails to be carried out as anticipated. The particular parties to the dispute may or may not have been involved before in similar transactions. At least one of the parties, however, will have performed many similar transactions in the past, so that its behavior will have become institutionalized, and there will thus be a pattern of practice or norm against which the deviational transaction can be appraised. The fact that this pattern of practice, which usually involve an external relation of a business institution, is of little social significance. The significant circumstances to be examined and weighed in determining whether a deviational transaction should be approved or condemned are first, the nature of the established norm of conduct against which transaction to be measured. Second, the nature of any general rules of law relevant to such transaction. And third, the nature of any special rules of law established by the party to govern the transaction. Now, my lord, the next two sentences are pregnant with consequence. Thus, no dispute can be said to be isolated or discrete. The parties may be, but not the institutional relationship in the performance of which the dispute eventuates. So we saw a practical example of this, my lords, in IRB infra, and this is why our courts, particularly our constitutional courts, my lords, must retain that limited scenario 3 power. And I am not, my lords, at all postulating that in 34 or 37 there should be a knight errant, a judge should be a knight errant, or impose subjective conceptions of justice or equity. No. But if the facts are undisputable, if they are clear, then lordships must permit, my lords, modification in scenario 3 also. Because that's my respectful submission. I'm so deeply obliged. Because my notes don't capture this because they were on a wider campus. I'll just, my lords, put in a revised note, just focusing on this.
Yes,
I'm
please.
so deeply obliged.
Next.
I'm only giving a short notes, Your Honor.